Good
Yes.
morning. My name is Alex Whiting. I'm the Deputy Prosecutor at the Kosovo Specialist Prosecutor's Office, but I'm not here in that capacity today. I'm here to welcome you to day 3 of the Global Rights Compliance Conference on Legal Uncertainty of Occupation, Crimea and Donbas. And I am moderating a panel on international and regional avenues towards accountability for violations of international criminal law, international humanitarian law, and international human rights law. We have an all-star panel, and my job is to do introductions and largely stay out of the way and moderate and let the speaker speak. So we'll go right into it. And the plan here, as I think has been the case with other panels, is the speakers. We have 4 speakers, and I'll introduce them one by one and let them speak. They'll talk, I think, for about 10 minutes or so, and then that'll leave plenty of time for questions. And I think there are various avenues. I think the idea is that you're supposed to submit your questions through the chat, but we'll also be looking for questions online. So without further ado, let's get started. And our first speaker is Dr. Rastan, who is legal advisor in the Office of the Prosecutor at the International Criminal Court. He's going to be talking about the International Criminal Court. As legal advisor, he deals with international law issues, in particular in relation to jurisdiction, admissibility, and judicial assistance. Rod has a distinguished career of practice in this field and also of writing. As with all the speakers, I'm not going to read their entire bio because it's available online. So if you're interested, you can see it there. And I think I'd rather save time for the presentations and questions. So Dr. Rastan, take it away.
Thank you, Alex, for the introduction, and thank you for the organizers for the kind invitation. And it's nice to see such a distinguished lineup of panelists. In particular, my former IHL professor, Dino, is watching, and thank you, Dino, for your message just now. It's really lovely to hear from you, and I'm sure to see you shortly. I've been asked to speak a little bit about the work of the court, the ICC, for about 10 minutes, and I'm sure the other panelists will also have a lot of insights in terms of accountability mechanisms and avenues for redress throughout the course of the rest of the panel, and hopefully we'll have a very lively Q&A session. What I'll do is just quickly run through for those who are less familiar, the findings of the court in relation to Ukraine so far, where we stand with our procedures and anticipated next steps, and maybe just to emphasize the complementary nature of the work of the court. As I think everyone knows, the ICC is not designed to replace national systems. Even when it exercises its jurisdiction, it's there to work in ideally a partnership scenario with national authorities. At the same time, it must exercise, obviously, diligence to make sure that where accountability is not being achieved at the national level, either because the national authorities are inactive or because they're unwilling or unable genuinely to do proceedings, then the court can try to contribute towards ending the impunity gap. And we can discuss what that practically might mean, given the actual reality of the court's limited capacities, finite capacities, and its engagement with multiple situations. So just quickly, I won't go into details, and of course, the previous panelists over the last days have talked about issues relating to classification and lawful occupation. So we can come back to that if you're interested later on in terms of how we've approached it so far. But basically, Ukraine has been with the ICC in the preliminary stage. So there are 3 stages, if you like, broadly speaking, in terms of the work of the Office of the Prosecutor. There are the traditional ones about investigation. Obviously, you have to investigate, and which we do ourselves. We are Office of the Investigator and the Prosecutor, like the ad hoc tribunals. So there's the investigation stage, there's a trial stage, the prosecution stage, where we go in court and we try to prove our cases. But before you even get to that investigation stage, uniquely for the ICC, which isn't a feature of other previous ad hoc tribunals, there is the stage called the preliminary examination stage. And this is really the stage where the court is deciding where to focus its activities. And this is unique because, as you know, in previous ad hoc tribunals, the decision where to focus accountability and also the time period typically have been set by bodies external to international courts. They've been decisions of the Security Council or agreements reached with the relevant territorial state to set up a hybrid court with UN assistance and so on. Whereas at the ICC, as you know, as a permanent court, one of its unique features is that the court itself can determine the scope of its own competence in terms of, beyond competence to la competence, in the sense of also where it will investigate and prosecute. And that, as you know, reflects broadly in terms of the treaty regime, in terms of the territory of its state parties. There are 123 state parties. So any crimes committed on the territory of its state parties that are Rome Statute crimes that occur after the entry into force of the statute or the entry into force of the statute for the particular state, any crimes on the territory or any crimes by the nationals of those state parties. And we can come into, go into that in more detail if you're interested later on. And then the other main alternative to that scenario in terms of the limitation of the court's jurisdictions to its treaty basis, if you like, is that the Security Council, as you all know, the Security Council has Chapter 7 powers that have been exercised in the past to set up international courts and tribunals. So one of the key elements also of the negotiations was to ensure that the ICC could be the forum to which the Security Council could refer situations for investigation and prosecution. The Security Council doesn't have to, and indeed there's been practice where the Security Council has decided not to refer, or there's been a veto on resolutions to refer situations to the court, famously for Syria. But there have also been referrals from the Security Council, such as Libya, specifically Libya and Darfur, Sudan, which thereby extend the jurisdiction of the court to potentially any UN member state, even if they're not parties to the Rome Statute. So those are the two broad ways in which happens. The third way, which is where Ukraine finds itself, is that a state which is not a party to the Rome Statute, but nonetheless wishes to accept the exercise of jurisdiction by the court, can do so on an ad hoc basis, can lodge a declaration saying to the ICC, to the court, to the prosecutor, we accept the exercise of the ICC's jurisdiction in relation to this time period or this territorial delimitation. They can't specify specific cases or perpetrators in the same way that referrals cannot, but they can demarcate a particular set of parameters and invite the court, if it wishes, to exercise its jurisdiction. And as you all know, Ukraine did that twice, first in relation to the events around occurring in the Maidan, and then thereafter extending that declaration in relation to the entire territory of Ukraine, thereby encompassing also events in Crimea and eastern Ukraine. The consequence of that for Ukraine is that under the Rome Statute, it creates international obligations for Ukraine. They are required specifically to cooperate fully with the ICC in its investigations and prosecutions. But other than that, they remain a non-party to the Rome Statute. And as you all know, I'm sure there's been ongoing discussions in Ukraine about the possibility of Ukraine to join the Rome Statute, draft legislation being put in place and so on, being discussed. So that's an ongoing development. So the ICC, particularly the prosecutor's office where I work, has been looking at Ukraine at this preliminary examination stage to determine whether the criteria are met to open an investigation. These criteria are in the statute, they're related to obviously subject matter. The prosecutor must be satisfied the crimes within the jurisdiction of the court have occurred. Admissibility, meaning that the kind of cases that the ICC prosecutor would likely focus on appear to be admissible in terms of complementarity. This means that those cases are not already being investigated and prosecuted genuinely. And in terms of what that means, in terms of the kind of cases the prosecutor might focus on, well, obviously the prosecutor can't yet determine definitively what cases he or she might bring. Obviously, you can't have a target-driven investigation, but of course, you can also have a general sense before you open an investigation of the types of the categories of conduct, the types of incidents that you're likely to focus on. Indeed, you have to be able to identify those as part of the threshold determination of whether or not there's a reasonable basis to proceed. So broadly speaking, there's that requirement to satisfy oneself that those cases would be admissible in terms of complementarity vis-a-vis national proceedings, that they would be grave enough in principle, and there are no countervailing considerations not to proceed in terms of interest of justice. I realize time is slipping fast and I haven't really got to the substance, but broadly speaking, what has happened in the last year is that the Office of the Prosecutor at the ICC, we've announced that indeed those criteria are met for opening an investigation in relation to Ukraine. We had already in 2019 identified our subject matter findings. We had specified that we found a reasonable basis to believe, which is a very low threshold, but nonetheless we were satisfied that there was sufficient evidence or information evidence to substantiate a basis to proceed with investigations in relation to alleged war crimes occurring in Crimea. And we can go through those, but a range of different offences from willful killing to outrages against upon personal dignity, compelling protected persons to serve in the forces of a hostile party, transfer of parts of the population outside of the territory, seizing enemy property, and so on, and deportation as a crime against humanity, and so on. We can come back to that in more detail. I'm sorry, I'm just giving a general sense of the findings that we made. And for Eastern Ukraine, we focused on the conduct. So this obviously related to the conduct of the Russian armed forces and proxies. And in relation to Eastern Ukraine, we focused on a number of categories of conduct perpetrated by both sides, if one may term it like that, both the Ukrainian government forces, as well as Russian armed forces, as well as other non-state actors in Eastern Ukraine. And this related to a cluster of findings related to the conduct of hostilities, which you're all familiar with, I'm sure, as well as a number of conflict-related detention allegations, again, alleged to be committed by both sides. So these findings were in relation to several categories of war crimes, and we identified those in alternative classification, both as international and non-international, depending on the findings that may result from an investigation. And as you know, we're not required to pin that down until we get to the trial stage, and even the trial chamber can hear alternative classifications so that it can satisfy itself at the judgment stage. And then in terms of admissibility, the new element from this last year was that having found subject matter the previous year, we proceeded to look at national proceedings, some of which have been underway, both in Ukraine as well as in Russia and in Eastern Ukraine. And we basically found that either there were categories where the competent authorities were inactive in relation to the categories of conduct that we were looking into, or alternatively, where they did appear to have open proceedings, typically against members of the other side, of the other party to the conflict. They were unable to progress their investigations because of lack of access to territory, primarily, or witnesses and so on. So we can go into more detail on those if you're interested. But in December 2020, the prosecutor announced those findings, that there is a basis to proceed with investigations. The next stage in the process, because Ukraine is not a state party, and because there has not been a referral, which can only be made by a state party, the prosecutor must submit an application to the pretrial chamber to seek authorization to proceed with investigations. And that's this. Yes, my time is up.
Well, I'm just mindful about time. I want to leave enough time for questions. So just to kind of put the punchline on it, has the prosecutor made an application? Is the criteria have been met for an investigation? When will the investigation start?
Yes, that's indeed the punchline.
In 30 seconds.
Yes, in 30 seconds. So we have not yet lodged the application, and this was quite a stunning statement to have made in December, but we felt it was intellectually honest to say it. We said this in relation to both Ukraine and Nigeria also meeting the criteria, that the criteria are met, but the court simply has no capacity with the current budgetary constraints to roll these investigations out. We have more cases in trial and in pre-trial than we've ever had. We have multiple investigations, including new ones we recently opened in Bangladesh, Myanmar, in Afghanistan, and now more recently Palestine. And so we basically made an appeal for state parties to give the court the means to be able to proceed. But for us, the next stage is to lodge that application. And then the last, I'll finish here, the last thing the prosecutor mentioned is that, of course, there's an incoming prosecutor about to take office. And so she said as part of that transition, she intends to discuss with the incoming prosecutor, and he will ultimately, Karim Khan, the incoming prosecutor, have to decide on issues of prioritization, how to prioritize rolling out these investigations, potentially closing down some of the existing cases or wrapping them up to be able to address these situations or to be successful in appealing for greater budgetary means to take these things forward. Thank you.
Okay, so the criteria have been met, on the verge of investigation if it's decided that it's a priority or if additional resources are provided to the court to do it. I'm sure there'll be more questions about this. I certainly have more questions, but we'll get to that in the Q&A. Now we're going to turn to Dr. Iryna Marchuk to talk about the International Court of Justice. Dr. Marchuk is an associate professor of international criminal law at the University of Copenhagen. Again, her full bio is available, but I will just tell you that she's written extensively in this field and has also been previously affiliated with a number of international courts, such as the ICTY, Special Court for Sierra Leone, and the International Criminal Court. Dr. Marchuk, the floor is yours.
Okay, great. Thank you so much, Alex, for a kind introduction, and I'm very grateful to organizers for inviting me. I'm delighted to join this panel of esteemed experts. So I will be talking about the ICJ and Ukraine's pursuit of justice. At the ICJ, I will be focusing on the case that Ukraine brought against the Russian Federation. I made a few slides, so it's easier for everyone to follow different stages of proceedings. I also think that some of you might not be lawyers, so it will be easier for you also to follow what I'm saying. So I'll share the screen, and also the presentation is helping me, so I'm not being carried away. I would like to say that in these 10 minutes, I can only scratch the surface, and now something is happening. I cannot share my presentation. I don't know what's happening. Just a second. It was then just disappeared. I don't know. I'm sorry. I don't know. I can't share my presentation, so I will just be speaking like this. And I don't want to take more time to sort out the technical issues. So let me just start by giving you the background and why Ukraine is pursuing the case against the Russian Federation. First of all, I would like to say that the case that Ukraine pursues in the ICJ is one of the many cases that Ukraine brought against Russian federations in different international courts and tribunals. So Rod was talking about the ICC, and also in this panel, we'll be looking at interstate proceedings in the European Court of Human Rights. And also there are a few interstate proceedings that have been initiated under Annex 7 of the United Nations Convention on the Law of the Sea. So Ukraine and Ukrainian politicians have been very vocal about pursuing this strategy of lawfare against the Russian Federation, and lawfare as a technique was frequently referred by the Ukrainian politicians. As we know, lawfare, it's the use or misuse of international law as a substitute for military means. It had a negative connotation when it was introduced by the retired American general Charlie Dunlap. However, we have increasingly seen that lawfare has been used in a positive sense, where parties are resorting to international law and initiate proceedings in international courts to defend their sovereign interests. So Ukraine seeks financial remuneration for the damages, which are estimated at 1 trillion Ukrainian hryvnias. I think this is roughly 38 billion American dollars. However, of course, Ukraine is not naive enough to believe that Russia will be willing to pay damages and will be compliant in the case the courts rule in favor of Ukraine. So what does Ukraine want to pursue? Ukraine seeks to hold Russia liable for alleged violations of international law under different regimes of international law, and also establish the truth about the conflict. In the opening statements, Wayne was saying that the conflict in Ukraine was marked by disinformation. So it's quite important that we have objective fact-finding, which is done by international criminal courts and tribunals. And also one of the benefits, if there are judgments that are ruled in favor of Ukraine, Ukraine can seek to exert reputational pressure on Russia in the eyes of the international community in order, for example, to maintain sanctions and hinder Russia to benefit fully from its economic initiatives, which require international cooperation. And the example which I was given before was Nord Stream 2 project. I think it's a really bad example right now. As we know, Biden administration decided to lift the sanctions, which means that the pipeline might be completed next year. So as I said, the dispute that Ukraine brought in the ICJ is one of the many disputes. And I roughly divide all the disputes that were initiated against the Russian Federation into two categories. So these are international law disputes of non-economic nature. So these are the proceedings in the ICC, the interstate proceedings in the European Court of Human Rights, and of course the proceedings at the ICJ. Also, there is interstate arbitration under the United Nations Convention on the Law of the Sea, which concerns Ukraine coastal rights, access to the Black Sea, Sea of Azov, and the Kerch Strait, and also a separate case regarding the detention of Ukrainian sailors during the Kerch Strait incident in 2018. In addition to this, of course, we have gas wars that have been taking place for a number of years, even before the occupation and the beginning of the conflict in eastern Ukraine. Also, there are a number of investor-state proceedings that have been initiated by Ukrainian companies regarding the expropriation of foreign investment in Crimea. And also there is this very big Ukraine-Russian dispute over sovereign bonds that amount to 3 billion, and that dispute is being handled in the UK. So let me just focus right now on the ICJ because I don't have so much time, but I hope you got an idea that the ICJ dispute is one of the many disputes. And sometimes when I read the newspaper articles by Ukrainian journalists, I feel that there is this one almighty international court in The Hague that will hold Russia accountable for all violations of international law. But this is just to draw your attention that there are different courts that are dealing with the alleged violations of international law. So in 2017, Ukraine lodged its lawsuit against the Russian Federation on the basis of the International Convention for the Suppression of the Financing of Terrorism. I will call it the Terrorism Financing Convention, and also on the basis of the International Convention on the Elimination of all forms of racial discrimination. At the same time, Ukraine sought the indication of provisional measures to protect its rights under both conventions. Three months later, which I believe was quite expeditious for the ICJ indicated provisional measures only with respect to Ukraine's claims on the CRD. However, the ICJ did not indicate any provisional measures in relation to Terrorism Financing Convention. When it comes to the provisional measures, they were quite modest as well. There were only 2 provisional measures that were indicated on the CRD. So the ICJ requested the Russian Federation to refrain from maintaining or imposing limitations on the ability of Crimean Tatar community to conserve its representative institutions, including the Majlis, and also the ICJ requested the Russian Federation to ensure availability of education in the Ukrainian language, which for me is quite disappointing considering like how many alleged violations in Crimea have been taking place: media harassment, politically motivated trials, murders, enforced disappearances, at least in the early stage of the occupation. In 2019, ICJ delivered its judgment in respect to Russia's preliminary objections to the jurisdiction of the ICJ. We won't have time to go through Russia's arguments. What I can say that the ICJ dismissed all Russia's preliminary objections, which is very good news for Ukraine, because that means that the lawsuit will be heard on the merits in its entirety. So the ICJ will be dealing with the allegations that Ukraine brought under both convention. This is under CRD and also under the Terrorism Financing Convention. So what's happening now? Now Russia has to file its counter memorial. The time limit was extended until July this year. Russia has been dragging its feet. They were asking for extension until the end of this year. However, the court decided that the 8th of July 2021, that's the deadline when Russia has to submit its arguments. So now I want to focus on the arguments and on arguments advanced by Ukraine and also counter arguments that have been advanced by Russia. And I would like to say that I'm only scratching the surface here. I won't be able to go into details. And of course, the legal arguments that are presented by the parties are more nuanced, but I will just focus on the overarching arguments with respect to the both convention. So when it comes to the CRD, Ukraine alleges that Russia pursues the policy of cultural erasure in Crimea in relation to non-ethnic Russian communities. So these are Crimean Tatars and Ukrainians. I do think, and I also commented on that in many blogs which I authored, that I don't think that the word cultural erasure is a suitable umbrella term. I think what's happening in Ukraine, it's quite clear to me that this is in Crimea, this is a policy of persecution. Cultural erasure sounds to me like a very soft umbrella term that was used by the Ukrainian team to summarize all the violations of international human rights law that have been taking place in Crimea. I do think that enforced disappearances and murder and politically motivated trials, they're not about cultural erasure, but they're about persecuting members of certain groups. What does Russia say? Russia says that the real issue is not racial discrimination, but the legal status of Crimea. And as we know, the jurisdiction of the ICJ is limited. The ICJ cannot rule on the legal status of Crimea and cannot rule on very important issues, for example, whether Crimea was able to secede from its parent state. So Russia tries to make it look that Ukraine packaged all of its grievances under the CRD convention, but there is no real dispute that the party have between themselves. When it comes to the Terrorism Financing Convention, it's even more complex. Here Ukraine argues that Russia has been supporting systematic terrorism by its proxies, the members of the DPR and LPR. And here Ukraine refers to a number of incidents. This is MH17, shelling of civilians in Mariupol, Kramatorsk, and Volnovaha, and also bombing of Ukrainian cities. What does Russia respond? Russia says that there is no plausible case of terrorism. There is armed conflict taking place on the territory of Ukraine. Russia has nothing to do with it, and the examples that Ukraine has been given in support of its claims, those allegations constitute war crimes, and therefore they fall outside the scope of Terrorism Financing Convention. So now this is my last slide. This was supposed to be my last slide that you were supposed to see, but now I'm coming to the most important part, and this is the outcome and the merits and the challenges that Ukraine has been experiencing so far. So I do believe, and this is my personal view, that Ukraine has more chances to succeed under CRD, but I do believe that Ukraine has to convince the ICJ at the merits of a broader spectrum of violations under CRD. And I hope that the ICJ will be able to look beyond the banning of Majlis and prohibition of education in the Ukrainian language. The prospects of Ukraine's case under the Terrorism Financing Convention are more uncertain, and this is because there is a very complex chain of proof that has to be present. So first of all, Ukraine has to prove that the acts that it complains of, they constitute the acts of terrorism. As we know, the crime of terrorism is a specific intent crime. So here Ukraine has to pay attention to the mens rea and the fact that the acts of violence were accompanied by the intent to intimidate the civilian population, or those acts of violence were committed with the special purpose of compelling the government to do some acts or abstaining from doing some acts. And the mens rea was a stumbling block in the Ukrainian case, because for this reason, actually, the ICJ did not indicate provisional measures under the Terrorism Financing Convention. The ICJ, during the first stage of proceedings, was not convinced that Ukraine managed to convince the court that the mens rea exists in relation to terrorism financing offenses and also in relation to terrorism, to the underlying acts of terrorism. So in other words, if the ICJ would accept the premise that the acts that Ukraine complains of, they constitute war crimes, and even if it's proved that Russia has been aiding and abetting those, aiding and abetting war crimes does not fall within the scope of the Terrorism Financing Convention. So the last 2 points that I would like to mention. This is evidence. It's very important that at the merits, Ukraine furnishes the court with high quality evidence. What I have seen so far, and I've been following oral proceedings, that Ukraine has been over-reliant on secondary sources, on the reports of international organizations, but Ukraine produced very little primary evidence. At least this is something which I could grasp from the oral proceedings and also from the memorial which Ukraine submitted in 2018 and which was made public. Also, if it's in the best case scenario for Ukraine, the ICJ rules in favor of Ukraine, of course, there is a possible risk of non-compliance by Russian Federation. It's not a new practice when powerful states do not want to comply with the decisions of the ICJ in contentious cases. I mean, everyone knows of Nicaragua case that US did not want to enforce the decision of the ICJ. So it might be as well that even if Ukraine wins the case, the Russia would clearly do everything possible to make sure that the decision is not enforced. And I think that I've taken more than 10 minutes, so I'll stop here to make sure that other speakers have sufficient time as well. And I apologize for the technical issues. Something happened. I just couldn't share my slides. Those of you who want the slides, please write in the chat. I'll be happy to share the slides with you. Thank you.
Thank you, Dr. Marchuk. That was terrific. Super interesting. I want to come back to the question about establishing truth, which you mentioned was a potential objective here, and whether court processes, and this is probably a question maybe for all the participants, whether these court processes are the best mechanisms, or because, as you said in your presentation, the law and the jurisdiction channel certain issues, certain topics are on the table, some fall off the table. So the processes shape what is in contention, what can be decided, and so that then raises a question about whether truth is obtainable. But we'll get back to that. So thank you. Our next speaker is Kirill Koroteev, who's going to talk about the European Court of Human Rights. He is a head of international practice at the Angora International Human Rights Group. Angora, for those of you who are not familiar with the organization, is an association of lawyers and human rights lawyers working on high-profile cases of human rights violations. And Kirill specializes in the European Court of Human Rights Law. Previously, he was a legal director of the Moscow-based Human Rights Center Memorial, which aims to protect human rights through international mechanisms and monitors human rights violations. Kirill, take it away.
Thank you. Thank you for the introduction and for the invitation to be here. And I'll probably start with a disclaimer, and that is I was not involved in any of the interstate cases, but I was involved in defending several Ukrainian nationals before Russian courts and before the European Court of Human Rights in relation to the 2014 events, mostly related to Crimea, so to the occupation issues. And my colleagues at Agora continue to defend Ukrainian nationals in Russian courts and at European Court of Human Rights. So even if I'm not on the record, I'm very often advising them. And I will pick probably where Iryna stopped. And that is the Majlis case, where I appeared on appeal before the Russian Supreme Court in Moscow, exercising de facto appeal jurisdiction. And that was the case of Majlis being declared an extremist organization. So what is important here is to show, and that is my major idea, the interplay between interstate cases, of which Iryna spoke, and also the interstate issues involved in the ICC, as Rod explained. So and individual applications before the European Court of Human Rights. So Majlis is particular in that there is an individual application by Majlis and its leading members concerning the listing of Majlis as extremist by the de facto Russian authorities and de facto Russian courts. But also it is a part of the Ukraine against Russia ICJ case. And my concern was that, Ukrainian authorities, not only they have never conducted the legal team that appeared for Majlis in the de facto Russian courts, even though apparently they were in contact with Majlis members, but the presentation of that case was unfortunately quite incorrect to the ICJ on probably minor points of procedure, but that shows the lack of detail and attention the Ukrainian government, or the lawyers representing the Ukrainian government, put to that case. And there, I mean, I think a careful reading of the judgments of the de facto Russian courts, and especially the de facto appeal judgment of the Russian Supreme Court, is itself revealing of ethnic-based discrimination, and the text of that judgment is quite clear. So it will be interesting to see the interplay, because the ICJ case has proceeded already to the merit stage, and what we see at the European Court of Human Rights is that there is so far 7 years already after the events. Only one judgment on the court's jurisdiction and admissibility in Ukraine against Russia concerning Crimea, and basically nothing else. Several individual cases have already been communicated, but these are well, one of them is the case of Oleg Sentsov, who is represented by a fellow Agora lawyer. Yet, there is unlikely to be a judgment in individual cases until the judgment in interstate cases given. And that takes already a lot of time. And the difference between individuals and states is that individuals die on occasion. So this has already happened in Georgian cases, where a lot of individual applications were lodged from South Ossetia and Abkhazia, and it took the court 12 years to decide interstate case. And the individual cases are yet to be decided. And in the meantime, quite a lot of applicants died. And it is said to come to the conclusion that this is likely to happen in Ukraine. That is why, by the way, we never invested as much resources as we probably could in Ukraine-related cases, because it had already been clear from the Georgian experience that the European Court of Human Rights will keep the dust on the individual cases until the interstate cases are decided, and this will take decades. And well, the situation is that, well, you just, as an NGO under the constant pressure of the Russian government, you cannot really plan for and strategize in terms of several decades. You cannot even do this in several days in Russia, but definitely not in years and not in decades. So that is one of the problems the IHRL proceedings raise. Another, well, the ruling of the Grand Chamber in Ukraine against Russia on matters of jurisdiction was, I think, welcomed finally by everyone, and it was very clear ruling that Russia exercises its jurisdiction in Crimea on the basis of effective control rather than territorial sovereignty. That was, and from the 20th of February, rather than the formal dates of what Russia sees as, Russian government sees as incorporation of Crimea into the Russian Federation. So from the days of first military operations in Crimea, and these are two major findings of the European Court so far in respect of Crimea. Again, we don't know how many years the merits proceedings will take, and there are other interstate cases pending, one of which is important in that it unites now two states, both Ukraine and the Netherlands, which concerns Donbas, eastern Ukraine, and in particular, with regard to Netherlands against Russia, the MH17, Downing. So, which also overlaps with other international proceedings before the Hague District Court in the Netherlands, which acts as a court under an international treaty between several states involved as victims in exercising passive criminal jurisdiction with regard to MH17. Now, what is important is again that these cases are 7 years past there. introduction, some of them at least, and there is not even a ruling on jurisdiction. There is also this time communicated to the Russian government a set of individual applications. So again, we have individuals and their case is even communicated, but again, unlikely to be decided before the interstate case, which takes ages. So individuals individual victims are again put on hold by the European Court of Human Rights. We'll see how it proceeds, but it's already quite a lot. So what is one of the important things here is not Ukraine or Netherlands, is Georgia. And I don't know whether alarms have been ringing in Kyiv when Georgia against Russia #2 was decided, but it should be as probably in The Hague, because in Georgia against Russia, the European Court found, well, putting itself in what we in Russia would call an ostrich position, so hiding head in the sand, that, well, if there is an armed conflict, the court cannot really establish jurisdiction. So actually, when it is an armed conflict, well, we don't know who is responsible. The court said with regard to the 5-day war in South Ossetia. And that is quite troubling because first, it is not really in conformity with international law as it stands. It's not in conformity with European Court of Human Rights' own case law. And in any way, it complicates very much the establishment of jurisdiction in Donbas. And especially it complicates the establishment of jurisdiction with regard to one of act that is the downing of MH17. So it is probably quite with regret that I have to be skeptical as to the remedies that the European Court of Human Rights may provide in the situation of Ukraine and Russian occupation and military conflict, at least supported by Russia or organized by Russia in eastern Ukraine. So what is then worse than that is that there are individual applicants who will, some of them probably, I very much hope most of them will live to see the judgments of the court, and they will be in individuals' favor. But again, we are in a situation where justice is very much delayed. So on the other hand, and to conclude, very recent views from Human Rights Committee. Now there is an individual application concerning Sevastopol, and which again has hardly given rise for discussion, because it looked like another LGBT propaganda case, because the Russian government bans any statements on LGBT, calling them LGBT propaganda and prosecuting them, albeit administratively. So one of the activists applied for an authorization of a gay pride in Sevastopol. He received a refusal. He challenged it in the courts in Moscow where he lives. So the courts in Moscow de facto exercised jurisdiction as it was possible under the de facto applicable Russian legal regulations. So the Human Rights Committee found a violation of the freedom of expression and freedom of association as if nothing happened. So as if that gay pride was to be held in Moscow, St. Petersburg, or Vladivostok, or wherever else in Russia, and there was only one dissenting opinion saying that the committee should have dealt with the issue of why and on which grounds Russia exercised jurisdiction under the covenant over Crimea, but Human Rights Committee has already failed to discuss the issue. So even though there is discussion in the concluding observations on Russian report, there is none in the jurisprudence, and this may have consequences for further litigation, which are yet to be assessed. And I'm concerned that this Human Rights Committee ruling was not really much discussed, or I probably missed it because, again, so much is happening here domestically, and quite unfortunately so. So thank you very much, and
Thank you. Thank you, Kirill. That very interesting, comprehensive. I'm at times pessimistic. I won't say gloomy, but just say pessimistic. I'm interested. I mean, I feel like the international mechanisms, at least the ones I've been involved in particular, the one I'm involved in right now, are often about delayed justice, and whether that's still, whether there, I believe in the work I do that that's still important and necessary, and even if it would be better if it were quicker, but and partly because of what happens along the way, and partly because of the outcome. So maybe during the Q&A you can talk more about that, about what the value is, remains, if there is one, from these extended delayed processes. But now we're going to turn to Olga Skrypnyk, who's going to talk about UN human rights mechanisms. Before I introduce her, because I think she might be speaking in Ukrainian, just to tell everybody that there is a, there's an translation interpretation button on your screen. Go down to the bottom right, there's a globe that says interpretation. You click on that. There are two options. It says English and Russian, but actually English is English and Russian is Ukrainian. Olga Skrypnyk is a chairperson of the Crimean Human Rights Group, which is a non-for-profit that promotes the observance of international law in Crimea, collects and informs the stakeholders on respect for the human rights situation in Crimea. She has a long history in working on Crimea. In 2014 to 15, she was the deputy head of the Crimean Field Mission on Human Rights. The floor is yours.
Thank you, Alex. Good morning, everyone. And I will continue in Ukrainian. Я представляю Кримську правозахисну.
Hello, I'm a representative of Crimean Human Rights Group, and our organization is working directly in the territory of the occupied Crimea. We collect evidence of the war crimes and we make those public. Our public headquarters are located in Kyiv, and today I'm joining you from the region that is called Arabetska Strilka. This is the place located only 12 kilometers far from Crimea. So I am very close to occupied Crimea, the closest you can be right now. And I am denied the opportunity to enter the territory of Crimea right now, but we have the network of monitors who have been collecting evidence for the past years, and those are the evidence of human rights violation. And today I will share the information about UN tools that have been used in the context of occupation. Mostly my inputs would pertain to the situation with Crimea, since we are working with this occupied region. And hopefully I will be able to share my screen now. Just a second. I hope you can see my screen now. Okay, great. So I will start my presentation. Over here, you may see the 3 tiers of mechanisms that are usually applicable. These tiers include UN organizations that are related to human rights protection, and there are also separate UN treaty bodies within the UN organizations and political bodies of the UN that are also operational in the sphere of human rights protection. UN organizations, I will not dwell upon that for too long. I just want to share those examples that are the most effective and that are applied most frequently. This is the OHCHR and also this is the mission that Office of High Commissioner on Human Rights that has been very helpful since the beginning of the conflict. And we've been in close cooperation with them at the level of quarterly reporting on the situation with Crimea and Donbas. With regard to this, we should also mention the fact that there are recommendations that are prepared both for Ukraine and for Russia. Unfortunately, Russia tends to ignore those recommendations, but as the Ukrainian party is concerned, many recommendations are actually carried out, and this is the advocacy tool for the civil society to be able to change the situation in terms of their protection of victims of armed conflict. And that there are also thematic reports in the past 2 years that have been prepared at the level of Secretary General. These are the thematic reports that are prepared with the consultations with the representatives of Ukrainian government and also Ukrainian civil society. These reports are actually quite limited, and when these reports were turned into the format of the Secretary General review reports, they have become abridged because the main focus of this report is just to give an overview of the trends, but not to have a closer look at the situation in greater detail. Over here, you may see the UN treaty bodies, both in Ukrainian and in English. These are the main treaty bodies that are operational in the context of armed conflict. With regard to Human Rights Committee, there are quite a few instances when we approached that committee, and recently even we sent an application to that commission on the claims of Ukrainian Orthodox Church rights being violated in Crimea. You know that religious groups are persecuted in Crimea, including Ukrainian Orthodox Church, and the main cathedral of the Ukrainian Orthodox Church in Sevastopol has been seized, and the religious community cannot use the premises. Respectively, the claims were lodged with the Committee on the Human Rights, and after that, the UN committee even urged the Russian Federation to seize the destruction of this cathedral. Apart from that, there were other reports that have been sent to other UN treaty bodies, the Committee on the Rights of the Child. Our organization collects information on militarization from the point of view of breaches of international humanitarian law, including the urges for military draw for the children. And this was the foundation for the claims, and we outlined the militarization as the violation of rights of children. As right now there is the militarization of civilians in Crimea. These are the trends, and we have outlined those in our report. Another opportunity that is of importance currently for Ukraine. This is the fact that Ukraine can offer its candidate to Committee on Torture, and our colleague, human rights advocate Oksana Matvichuk from the Center of Civic Rights, she has been nominated to be the candidate from Ukraine, the Committee on Torture. And there are also candidates from Russia, China, Japan, and Denmark. They will all send their candidates, but this is the first time that Ukraine has an opportunity to be represented in that committee in particular. Apart from that, Ukrainian organizations also send reports and applications to the Committee on Torture about the numerous incidents on the violations of the prohibition of torture, since unfortunately politically motivated persecution resulted in over 100 people being detained, and those are the cases with political reasons, political motives, and in many of those cases there are tortures that take place. Another level that I would like to discuss, another tier, pertains to the political bodies. There are two of them, the UN Human Rights Council and the UN General Assembly. Probably Ukrainian society is well aware about the activities of UN General Assembly. It is often mentioned in streamlined media, and there are two resolutions that pertain to Crimea. I will tell about that a bit later in detail. But firstly, let me dwell upon the UN Human Rights Council. This is the council that has special procedures in place, like working groups. In few cases, we applied to the working group. In the case of Volodymyr Balogh, our colleagues have sent their applications to the working group on forced disappearance. And there are also special rapporteurs and independent experts working under that council. The special procedures are either focused on specific region or on a specific type of offense or violation. For instance, freedom of speech or freedom of religion or prohibition of torture. It means that you could apply to the specific working group or special rapporteurs. Ukrainian missions also have visited the Human Rights Council, and some of those pertain to the situation in the occupied Crimea. There is universal periodic review that is the tool that has been actively used as the advocacy tool to state the violations of the human rights violations. This is the procedure for all the countries reporting about the human rights respect, and in return they get the assessment by other countries, as well as the recommendations are sent to the countries by the other members of this universal periodic review. But unfortunately, not always those recommendations are exercised. I would like to say that this mechanism is also applied to the Russian Federation, but also Ukrainian human rights organizations are using this opportunity in order to see the changes happening in terms of protection of rights of those who have been affected by the conflict. For instance, in 2017, Ukraine was provided with 190 recommendations. Ukraine managed to fulfill 163 of those, and they pertained to the protection of civilians that were affected by the conflict. And over here you may see the information about the organizations that work both with the Donbas and with Crimea, and most recommendations have been actually fulfilled, but unfortunately not all of them. Some were remaining and this is the tool that has been often used. Getting back to UN General Assembly, this mechanism is actually well known since there are two resolutions that pertain to Crimea. The first resolution is relatively new. You may see the resolution that pertains to militarization of the Autonomous Republic of Crimea and the city of Sevastopol, and also of the Black Sea and the Sea of Azov. This is the resolution that was the response to the situation of 2018 when Ukrainian sailors were detained, and this resolution contains the urges to the Russian Federation to stop the military draw for the Ukrainian citizens to the Russian army. And recently we have got the information from the human rights organizations that Russian Federation is using the educational system for the propaganda, military propaganda, and the propaganda of military service in the Russian army. This is what's included into our claims as well. And there is another resolution that has been passed on an annual basis since 2016. This is the resolution that pertains particularly to the human rights in the occupied Crimea. We may trace changes in the body of that resolution, since this is the tier of the political decisions in UN mechanisms. With that, we see the reflection of the overall trends in world politics. But this resolution is one of very important documents. And let me give you an example of what's been changing in that resolution and what we can actually trace. This is the wording with regard to the Russian Federation. Of course, it is called the occupying state, occupying power, but starting from last year, the authorities that are operational in the Crimea have been framed as the authorities of the occupying power. And also we could mention the resolution of 2020 that contained recommendations in the final provisions with the urges to UN member states to support the international platform for countering human rights violation in the Crimea. And that was the backbone for the creation of the Crimean platform. And we see it echoed also in the resolution. For human rights advocates, the resolution is also the tool to protect victims of political persecutions. It is a rare occasion when particular names are mentioned in the resolution, but when it comes to Crimea, such examples do happen. At the beginning of these resolutions being passed, they were the names of political prisoners who have been detained. Oleg Sentsov, Valdemar Balan, and Iryna Sinkuku. Two of them were released with the exchange of prisoners program, and I think that it was an important factor contributing to those two people being released. This resolution was a contributing factor. Now, in the recent resolution of 2020, there are also names of the political prisoners. Iryna Sinkuku, he is a Crimean human rights advocate, and Samir Mustafayev, he is also the famous Crimean human rights advocate and coordinator of Crimean Solidarity. But I would like to reiterate that this is a rare occasion when actually particular names are mentioned in the resolutions. The work on the resolution is ongoing throughout the year. Firstly, the committee works on the draft, and later on the resolution is actually passed. So that's it from my side, and I think we should make some room for the questions and answers. Thank you.
Thank you very much for that excellent presentation, and thank you to the interpretation, which I thought was superb. So first of all, participants, please either raise your hand if you want to ask a question directly or make an intervention, or, oh, I see there is a hand up already, or send a message on the chat. And we can put the question. I'm going to put two questions out there, but then I'm also going to allow Sergey Mezal to ask a question. My two questions, just to throw them out, is how you've all spoken about your own kind of lane, and how maybe one thing you could do is talk a little bit about how your area interacts with some of the other areas that have been talked about, and either supports or draws or depends on, or what the kind of interactions are between the different bodies. You know, for Rod, for example, I know that there's International Criminal Court will hold back waiting for other actors to act. And then the second question is really, it goes back to Dr. Marchuk's point about establishing truth and what the goals are, and to kind of put that question to all of you in terms of, you know, what is to be accomplished by these different approaches, these different courts, tribunals, processes. What are the goals? What are there short-term goals? Are there long-term goals? Is it just is the process itself the aim, or can it be part of the goal? Are they symbolic goals? Is the goal to support other efforts, whether it's political or other tribunals? Are the outcomes important, or are they not important? Are there risks in pursuing these? If they're not successful, is that a setback, or can there be success in failure? So I'll ask you all to reflect on that. But before I do that, I'll give Sergey Mezal the floor.
Thank you, Alex. Good morning or afternoon, wherever you are based. I have two questions, one to Dr. Rastan and one to Dr. Marchuk. So to Dr. Rastan, is the ratification of the Rome Statute by Ukraine, is the non-ratification of the Rome Statute by Ukraine considered a factor why the situation in Ukraine is not currently prioritized by the ICC Office of the Prosecutor? And if so, what is the relative importance of this factor among other pertinent factors? And will the ratification immediately solve the problem? And then I have the question to Dr. Marchuk. Which determinants prompted the transformation of attitudes towards the concept of lawfare from mainly negative to, as you noted, generally positive perceptions thereof? Thank you.
Those are excellent questions. I'm going to ask I'm going to call on the participants in a slightly different order. So maybe we could start with Dr. Marchuk.
So thank you very much for this question. I think that I start with the first question that was posed by Alex. It's about the limitations of international courts in establishing truth. I think definitely this is the case, and international courts, as we know, are limited by their jurisdiction. It's of course very unfortunate for Ukraine that the ICJ will not be able to deal with the real issues at stake. And we are talking about self-determination, remedial secession, the use of force, aggression, because we know that the court will deal squarely with the allegations under the CRD and also the allegations under the Terrorism Financing Convention. So what Ukraine can get out of it is partial truth. And then I think it was a very good second part of the questions. What are the setbacks? So for example, if the ICJ were to establish only few violations on the part of the Russian Federations of certain provisions of the CRD, Russia will be very keen on exploiting this and saying, okay, well, you know, this allegations that Ukraine have been making about the widespread human rights violations, they don't have place, and the ICJ, which is the highest court, only established few violations. So of course, there are different pros and cons in engaging international courts, because they will never be able to provide a holistic account what has been happening during the armed conflict. The second argument which I would like to make is that engaging international courts is not only the only tool in establishing the truth. And I think that what the Ukrainian government has to consider is whether they are willing to establish Truth and Reconciliation Commission and involve international experts. And I think that if such commission were established, Ukraine will be able to get much more out of it than only relying on fact-finding in international courts that are very much limited by their jurisdiction. The question which was asked by Sergei is about the lawfare. Okay, so why the concept of lawfare had a very negative connotation beforehand, and now when we look at the concept of lawfare, it's used in a more positive sense. And I think this is largely to the geopolitical events that have been taking place in the world. We have seen that powerful states have been misbehaving badly. So weaker states or states with weaker geopolitical presence, they have been taking these powerful states to international courts, and they employed international law, as they call the lawfare, as a means to defend their sovereign interest. And it's not only relevant to the situation of Ukraine, where Ukraine, the country that cannot fight the Russian military, is preferring to take Russia to international courts. That also concerns, for example, China. I'm thinking about the South China Sea case, where the Philippines took China over the maritime rights in the South China Sea, and as we know, China lost the case. Also thinking about the situation of Afghanistan, which has been pursued in the ICC, potentially implicating the responsibility of powerful states, including the United States. Also, the very fortunate decision of the Trump administration to move its embassy to East Jerusalem, which is contested territory. So we can see here that the weaker states are no longer afraid of taking powerful states to international court, and so they present it as the defensive lawfare, a lawfare which is pursued to defend their sovereign interests. So that's a very short answer. I also wrote a very comprehensive piece which was published last year in UC Davis Journal of International Law and Policy. I'm not sure if Sergei has seen this piece, but I will be happy to share this with him, because it's precisely touching upon the issues that he flagged and about the evolving nature of the concept of lawfare with focus on international courts.
Terrific, thank you. Dr. Rastan.
Sure, thanks, Alex. I'll be very brief, hopefully. On your question about interaction, absolutely, as you know, the court, the ICC does consider, of course, the findings of other international bodies that have examined a similar set of facts. Doesn't draw conclusions on their factual findings, but their legal interpretations can often be very helpful, persuasive. The parties often refer to them, prosecution, defense, legal representative, victims. So that would certainly relate to the European Court of Human Rights, the ICJ, also even findings in UN reports, special rapporteur reports. So certainly there's a dynamic interaction there, and that's already played out in existing cases and trial judgments. That also reflects that kind of interaction that you've seen at the ad hoc tribunals, obviously. On the question of ratification, Sergei's question, non-ratification is not determinative on this question, and you can see that because on the same day that we announced the conclusion of the assessment on Ukraine and the fact that we couldn't proceed because of lack of means, the same day we announced those findings for Nigeria, which is a state party. The only difference that would happen if Ukraine was a state party is that it might have referred the situation, and it could still refer a situation. So if there's a referral, there's a slightly different procedure for opening investigations. Instead of the prosecutor seeking authorization from the judges, the prosecutor can proceed directly. And the way so far the appeals chamber has interpreted it is that while the prosecutor has some discretion in terms of moving forward on these applications for the pretrial chamber on his or her own motion, where there's a referral, there's a duty to open the investigation. So, for example, you saw that in the Palestine statement, we emphasized the point that after we sought and obtained a judicial ruling, given that there was a referral, the prosecutor is duty bound to open the investigation. So let's say if there was a referral from Ukraine we have the same positive findings, there would have been a duty to immediately open the investigation. But that's, again, only a legal distinction, which has limited practical differentiation, because practically speaking, even if there was today an investigation that was formally open in terms of saying that we've moved to that stage, practically the prosecutor would be in the same position. How do I carry this out when I'm already overstretched on so many cases, and this model, this budgetary model, is not working, it's not sufficient for the resources. So this is also why we already made that a predicament and dilemma public in December, when we reached our conclusions, prior to lodging the Article 15 applications. Because even if we lodge them and obtain judicial authorization, we're in the same position, we're still stuck. So certainly our goal is still to proceed with those applications, and this is a matter that the incoming prosecutor will examine and review. But the predicament isn't solved by technically moving it into the investigation. You have to have the means to carry it out. And then, of course, that touches upon the question that Alex mentioned earlier about delayed justice, which is something that we've experienced, of course, in Georgia, where there was a time lag between opening and the crime base. It's a continuing concern for us in Ukraine. But one of the things I think the court has got better at, and more recently, and certainly we do a lot, is that already at the pre-investigation stage, we are preserving evidence, we're seizing opportunities to take testimony at the seat of the court, we are interacting with other actors who are on the ground. And in terms of how we organize ourselves, we already have advanced teams, including prosecutors, investigators, analysts, assigned to these situations that are approaching the investigation stage before the actual investigation is open. So that advanced team apparatus is already in the planning stage for Ukraine and Nigeria, even if in a nuclear sense. But absolutely, delayed justice is obviously a very real concern. And then last, in terms of the goals, I'll let others maybe comment upon it. Certainly, as you know, the ICC model is one to embrace complexity and diversity of mechanisms, whether national, regional, domestic, with a priority given to domestic assumption of responsibilities for these crimes. And obviously the next panel will examine that in detail. But for the ICC, at every moment, and for the prosecutor's office, it is the goal is to actually focus on that effort, and to the extent possible to see how we can also fit into a much more complex set of mechanisms that might address transitional justice more broadly. And we are obviously just part of that process. We assume a humble posture towards this complex environment, but it's true, as others have said, and I think as Iryna said, the ICC sometimes appears to dominate the landscape in a way that doesn't reflect perhaps reality. So we're certainly keen to emphasize the ICC's limited role and the priority that must always be given to the national level. Thanks.
Thanks, Rod. Can I ask a kind of a narrow technical question? I understand about the resources, but why not proceed with getting the authorization to open the investigation? Because that process can take 3 to 6 months, sometimes even longer. So you've been taking a year at times. And so you get a jump start if there's a decision to prioritize, and opening the investigation, while, as you say, without resources, it doesn't practically change anything. It does unlock a number of powers and tools that would then be available to use right away if you had the opportunity. So why not take that step now, even if you don't have the resources?
No, absolutely, and that's what we're working on, is to take those steps. I think the last consideration is that there is a new prosecutor coming in, and the current prosecutor committed to discussing with Kirill how that prioritization will happen. There are some things that have to proceed because, like, as I say, there are referrals, and if she reaches determinations, those proceed. Some things that are well advanced. But on Ukraine, Nigeria, that's the goal, is to get to that next stage. But also to indicate that doesn't solve it. But yes, there is the benefit that you have more additional powers. and you're able to seize those opportunities more easily than at the pre-examination stage. So that's the goal that we can continue to be committed towards.
Sergey, I see your hand up. Is that a new question?
It's a follow-up to Dr. Rastan, if I may.
Yeah.
In the situation of the lack of resources, as you described, will Ukraine's ratification of the statute and therefore financial contributions to the regular budget of the ICC help to solve the problem of financial constraints? Because currently Ukraine is a non-state party, does not provide any financial, is not obliged to provide any financial contributions to the ICC. So will the Ukraine's contribution, whatever amount it is, I don't know exactly, help to solve the financial burden? Thanks.
I mean, I would say in general terms, of course, having more state parties and greater contributions to the budget will always be able to assist the office being able to respond. And certainly the Office of the Prosecutor is very keen on Ukraine obviously becoming a state party, as we are generally, to promote universality. So my comment about procedurally it not making a difference in terms of the current assessment was just to give you a clear understanding of the legal criteria. Ratification, non-ratification is not a legal criteria, but of course, as a matter of hope and aspiration for universality, of course, we are very keen for state party accessions to states become parties, and certainly in the case of Ukraine, we've been keen to support those efforts. And yes, indeed, if they are a state party, they would have the ability to contribute. But it's also an obligation that resides with all state parties. The court is also in arrears with existing contributions. And every year there is obviously a stress on zero nominal growth. But as that court budget remains stable and unchanging, the demands on the court, whether from referrals or new suspects being surrendered or new situations becoming ripe for investigation, it makes the mismatch so large that it becomes unsustainable. So I think this is the frustration that's expressed, if you like, by the prosecutor, current prosecutor. I'm sure the incoming prosecutor expressed the same, that we have more and more of these situations that are now ripe for rolling out. So we are ready to roll out an investigation, specifically in relation to Ukraine. But how do we do that? Practically speaking, how do we do that when we are already stretched with the current resources and simply unable to respond? So it's also a way of managing.
Rod, you just.
Sorry, managing expectations. My hand hit it. And just to emphasize the persisting obligation of the international community as a whole and state parties. The court cannot be expected to absorb everything without being given the means to do so. So we certainly would hope to be able to advance with the investigation. So it's a practical issue. And if those budgetary means don't come to us, then it doesn't mean that Ukraine and Nigeria are never to be open. It just means that the incoming prosecutor has to decide, okay, then how do I manage this? Do I close off something else in order to make room for Ukraine? How do I manage the workload? But the point is that this workload has always become unsustainable for the Office of the Prosecutor.
Thank you, Rod. Lena has given me the authorization to take 5 extra minutes. So we'll take another 5 minutes and then we'll take a break after that. But Kirill, could you take the floor and answer the questions that are addressed to you? And then we'll get to Olga.
Yes. So there was a question coming on chat, and that concerns the Netherlands' participation in the MH17 case and the joinder of Ukraine against Russia Donbas case with that of Netherlands against Russia. So as I said, there is hope that the Netherlands would probably reinforce the submission on the applicant government's side, but hope is probably the major word here, because, well, we don't actually know what the Netherlands government sent to the court. They do not appear to be eager to publicly share their litigation papers. Not that they have to, but again, we'll have to wait until the hearing, which means probably another few years, to see what they will tell the court. The only thing this will, the joinder of the two cases will make different is that, well, they will be decided together, rather than one will be decided and another will take another few years to decide. I would probably react to your remark, Alex, in the closing of my presentation about justice delayed or denied, and what is the importance of judgments given many years after. There is, of course, and it is important in ending the dispute, however long it takes, and in saying who was wrong, if there is someone who is. But my major problem is that the court deliberately delays the individual cases until interstate cases are decided, and individual cases, have to wait, and this is, there is a difference between states which do not die as often as individuals. So my major concern is that many of the applicants will unfortunately die before the court reaches its judgments. And I represented many victims from Chechnya who died before they saw a judgment from the European Court of Human Rights. So it is very unfortunate when you see this, and I saw this relatively often.
Okay, thank you. And Ms. Skrypnyk, I'm going to leave the last couple minutes of our session to you.
Thank you. It's about question about committee. Sorry. Okay. Yes, for example, submission about situation with rights of children in occupied Crimea in the context of militarization and occupation of Peninsula was submitted last year to Committee of the Rights on the Rights of Child, and I said a few words about this submission in my presentation. And if you want to see more, you can see link to this submission in our chat. And it's example of this submission. You can see structure of reports, and it's about militarization and how militarization influence on rights of children in Crimea.
Thank you. Well, thank you, everybody. Thank you to our 4 speakers for their interesting presentations and the answers to the questions. I learned a lot. We are now, we'll take a 15-minute break and resume at 10:50.